Are you owed monies by a business or an individual residing in the state of New York? If so, you should know how long you have to collect your claim in New York State. Hello, and thank you for joining us today. My name is Jocelyn Nager, the managing partner of Frank Goldstein and Nager. In this segment, we will focus on understanding statute of limitations. This video is for informational purposes only and is not intended as legal advice. Debt collection claims can go stale. Once the time to pursue collection expires, attempting to collect can be unwise, unlawful, or just bad business. That goes for claims placed for demand, mediation, arbitration, and litigation. The length of time you have to pursue a claim is referred to as the statute of limitations. The amount of time varies based on the type of debt. In New York State, the statute of limitations to bring commercial claims, business to business B2B for services rendered is 6 years. For goods sold, 4 years based upon the Uniform Commercial Code, UCC. The statute of limitations when collecting from consumers is 3 years, just shortened a few years ago from 6. Even if the statute of limitations has expired for mediation, arbitration, or litigation, you may still make a demand for payment. However, there are important differences depending on the type of debt. For commercial debts past statute, you are not required to inform the business that the debt is stale or past the statute of limitations. You can still send demand letters or make calls. For consumer debts past statute, you must clearly advise the consumer that the debt is past the statute of limitations. Additionally, debt collectors cannot threaten litigation against a consumer for debts past the statute. Although you can place a debt that is stale for debt collection, going beyond demand and into mediation, arbitration, or litigation is a very bad idea. For cases involving consumer, the lawyer needs to specifically state that the debt is within the statute of limitations. The consumer would have an absolute defense to the case in that the debt is stale, and the debt collector would open themselves up to potential liability by violating federal and New York statute laws. Making demand on commercial claim that is past statute of limitations does not require disclosure. And if suit was brought on a debt past the statute of limitations, the defendant would have an absolute defense. Even if the commercial entity does not answer and defaults in the legal action, the lawyer is specifically required to submit an affirmation to the court that the debt is timely within the statute of limitation. If your debt collection lawyer accepts the stale claim, which is most unlikely, a debt collector can try to encourage your debtor to pay the debt by sending letters or calling, so long as they do so within lawful parameters. They cannot threaten to sue a consumer if the statute of limitations has passed. When calculating the timeliness of your claim to make sure it's within the statute of limitations, bear in mind that making a partial payment or acknowledging the debt in writing extends the statute of limitations. If you have found this information helpful and want to learn, please like and subscribe for additional videos and to our weekly blog, which offers tips to collect. Please check our website for updates on New York debt collection, updates on laws impacting debt collection, and some case studies. If you would like to contact us, you can reach me at jnager@ffgnesqs.com and by phone 212-686-0100 extension 12. Frank Goldstein and Nager. We have the experience that pays.